How are you in general? Okay.
Yes. Okay.
Yeah, I'm fine, thank you. Really great to see you.
Yes, I'm too. Well, probably there will be some conference offline soon.
Hopefully.
Probably in Dubai. No, are you going to go there?
Hopefully. Okay, so I think we'll be starting.
Yes, I can start now.
Yes.
Good day, Maria, and everyone. Good day, Mr. Max.
Hello?
Me? Can you hear me?
Yes, I hear.
Okay. Maria, it's nice to have you again on the program. And hello, everyone. Welcome to week 7 of the JIIPCC Mentorship and Internship program. My name is Christiana Longe, and I will be anchoring the program today. I was a mentor in the first section. I was a mentee in the first section, sorry. And your presentation and teachings of the first section has really been of great benefit to me, and it has really opened my eyes as well. So I want to say thank you very much for that. This program is recorded and streamed live on all our social media platforms. I would quickly like to introduce the program quickly and then also share the objectives with every one of us. The program is a quarterly intellectual property mentorship program for law students, young lawyers, and intellectual property enthusiasts across Africa. Our mentees are afforded the opportunity to access valuable intellectual property advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced IP mentors. This program seeks to encourage continuous intellectual property training, development, and evolution in Nigeria and also the African as well. You can watch our videos by searching for JIIPCC on our YouTube and Facebook platforms. The objective of the program is to provide access to intellectual property guidance, training, and resource materials for students, young lawyers, and IP enthusiasts in Africa. It is also to facilitate dialogue and network among experienced and less experienced intellectual property practitioners and stakeholders, to transform mentees into intellectual property mentors and leaders for the next generation of mentees, to facilitate further intellectual property mentorship, internships, scholarships, and IP-related job placement for the mentees. Once again, you are welcome, Maria, and all our guests and mentees that are present. I would quickly like to read your profile so we all know who you are before you start the presentation.
Okay.
Okay. Maria Koval, I don't know if I got it right. I'm sorry if I didn't. Maria Koval is the counsel and head of the intellectual property practice at Redcliffe Partners. She specializes in all intellectual property issues, including trademarks, designs, inventions, domain names, copyright, trademarks, and data protection matters. Maria has a long track record of advising multinational and Ukrainian companies on various IP issues such as possible rights infringements, strategies on IP rights protection, license, and franchise agreements. Maria regularly handles litigation on various intellectual property issues. Her experience covers a wide range of sectors, including information and communications technology, advertising and marketing, pharmaceuticals and healthcare, and food and beverage. Maria is also a domain name arbitrator of the World Intellectual Property Organization, Arbitration and Mediation Center. Before joining Redcliffe Partners, Maria worked as an IP lawyer with different Ukrainian law firms. Today, she'll be talking to us on domain name dispute resolution at the World Intellectual Property Organization Arbitration and Mediation Center. So Maria, you'll be taking over for now for about 15 to 20 minutes. You're very welcome. We're glad to have you here. I've benefited from your teachings and lectures, and I'm looking forward to another one today as well. Thank you very much. You're welcome.
Thank you very much, Christina, for your presentation and introduction of me. I greet all mentees who participate in this internship program. I think that all internship program organized by Juliana were quite well. I like them very much, and I hope that every session and every part of this program will be very helpful for you and very interesting. Like Christina also already mentioned, I'm Maria Koval. I'm the arbitrator in the World Intellectual Property Organization. I decided international cases regarding domain names. So I'm an arbitrator in domain name disputes. I have one track of consideration of these cases. I decided already more than 55 cases within the 2 years. Today I will talk about the internet domain name and uniform dispute resolution procedure in general. I will talk about some interesting aspects of this procedure, and I hope that it will be very interesting for you. Christina, and I'm sorry, can I share my screen for presentation? Yes?
Yes, you can go ahead.
Can you see my presentation? Yes?
Yes.
Okay. Yes. So let's start. What is a domain name in general? With no relation to any intellectual property rights. It's simply the address where internet users can access the proper website. So there is a technical indication of this term, which is very important to understand, that it is not some object of intellectual property rights, and it has no protection like intellectual property rights. It's just a technical aspect of the internet. So it's a part of the internet where somebody can find some information on appropriate on concrete website. Also, domain is the name used for addressing computers and resources in the internet in general. And also, if we are talking about the technical indication, so the part is of hierarchical internet address space, which has a unique name. So we are talking about some unique names that can be very important for trademark users, for trademark owners. I'm sorry. Why? Because usually all trademark owners wants to reflect their trademark, especially well-known trademark, in their domain names. So there are some kind of war now in the internet when the trademark owner struggles against some cyber squatter. We will talk about all of this later, especially for this part of internet, like domain name. So let's continue. What is it, cyber squatting? Cyber squatting is a legal activity anyway. It is a registering and using of internet domain name with bad faith, with intent to profit from the goodwill of a trademark belonging to someone else. So we call it cyber squatting, and in the world it has the name cyber squatting. The person consequently has the name cyber squatter, which owns, register and owns this illegally cyber squatted domain name, and then offers to sell this domain name to the person or company who is the trademark owner. So its activity now is very popular for some persons, especially we are talking about natural persons. They are usually engaged in it with some intent to get some profit from this. We are talking about money. Cybersquatting refers to illegal domain name registration or use, but in general, there is no responsibility for such illegal activity. It is understandable that the primary process of cybersquatting is to steal or misspell a domain name in order to profit an increase in website visits. So when, for example, somebody illegally registered well-known trademark, for example, Facebook or Apple, and he or she added some code, so com, net, or org to this. We are not talking about com, of course, because it is occupied already, and he can own this domain name, and then he's trying to suggest to trademark owner, for example, to Facebook, to sell this domain name with the sole intent to have a profit from this illegally registered trademark in domain name. So the struggle against cybersquatting begins last century. In 1999, World Intellectual Property Organization adopted international procedure on alternative resolution of domain name disputes. So now it is in force already 40 years, or 20 years, I'm so sorry. It is a very successful procedure now. I will talk about some statistic data later, but I need to say that it's a very good procedure in general for reverting the illegally registered domain name to their owners, trademark owners. Trademark owners, due to this international procedure, has a possibility to resolve obvious disputes in respect of illegally registered and used domain names. It is non-judicial dispute resolution. It has no relation to court proceeding or any administrative proceeding or official proceeding in any country. So it has an extra judicial force. This procedure applies through mandatory domain name registration condition. What does it mean? It means that when somebody registers a domain name, he should sign the registration agreement, which contain already some conditions regarding this international procedure. This uniform domain name dispute resolution policy applies to all old, so-called old domain names, namely com, org, net, etc., and to new ones. There are so many of them now, Attorney Club and many others. This procedure also applies to 75 country called top-level domains. So, for example, we can file complaints not only for com, org, net, but in respect of 75 country called top level. Besides, Ukraine joined this procedure 1 year ago. So we have such procedure also in force with respect to UA and .com UA domain names. I must mention that it's very successful procedure now for Ukrainian and for trademark owners who has illegally registered domain names in Ukraine domain zone. So it's very helpful, and we now can avoid legal proceedings in courts. WIPO Arbitration Mediation Center was established in 1994. Now it's a part of World Intellectual Property Organization. It has 2 offices in Geneva, official, and from 2010 has an office in Singapore. From the date of the centers established, the center resolved more than almost 50,000 domain name disputes with participation of parties from 177 states, and in respect of almost 80,000 domain names. So this is a statistic. The WIPO publishes this statistic every year, and now we have more domain name disputes in comparison with last year's. So I think that it is due to launch of some country code domain names dispute resolution, and besides for Ukraine also. So now I think that this domain name disputes only will increase. So you can see the top 10 plaintiffs' fields of activity. As you can see, the most interesting for cyber squatters is the banking and finance field, also internet and IT. We are talking about Facebook, Apple, Google, and so on. Also biotech and pharma. As you see, hotels and travels, retails, entertainment, electronics, and food has not so big parts in comparison with banking, finance, biotech, and internet and IT. So this is a picture of top 10 plaintiffs from all over the world, from every country, who file the complaint almost every year, and has, I think, the most number of domain names in the WIPO Arbitration Mediation Center. What are the advantages of this international procedure? First of all, it's speed. So from the moment when the complainant files the complaint to the center and till the moment he obtains a decision and consequent transfer of domain name to the legal owner runs no more than 60 days. So this is a standard procedure that you can 2 months for filing and for the whole proceeding for the signing a decision by arbiter. Besides, we have 2 weeks for writing the decision and for resolving the case in general, but no more than 60 days. And this term can be extended by petition of some parties or by arbitrator if the case is complicated or the parties want to file any additional documents or any additional facts to the case. The second advantage is internationality. So it's an extraterritorial effect of this procedure. For example, the complainant can own trademark rights in any country, even only in one country. And for example, the respondent has a location in Ukraine or in another country where the trademark owner has registered his trademark. It will not be a bar for the application to the center and obtaining a decision. So it's a very good condition for this procedure, I think, because you don't need to go to the court in any jurisdiction in any country where you want to take off your legally registered domain name. The third one is the cost. Resolution of the case in respect of one up to 5 domain names by single panelist costs $1,500. No more expenses, no more fees. The complainant should pay or the defendant should pay. If we are talking about resolution by 3 panelists, it's we resolving the case by 3 panelists. So I can be, for example, presiding panelist, and 2 my colleagues can be the 2 another panelists. So it will cost $4,000. Also, no more fees and no more any expenses. Convenience. Parties' personal presence, including teleconference, video conference, Zoom, and so on, any online presence is not requested. So no requirement to be online or offline during the resolution of these cases is not requested. Also, one of the, I think, the main advantage of this procedure that the decision domain name transfers, we are talking about the transfer of domain name, enforces directly by the registrar. So the party, the complainant, namely, doesn't need to do any acts for enforcement of the decision. The decision is forwarded by the WIPO Arbitration Mediation Center to the registrar directly, and the registrar has 10 days for enforcement of this decision. Decision of Arbitration Mediation Center are available for review They are published, all of this decision published on WIPO website. I indicated a link to it. It's very interesting to read some decision from this website, to understand the procedure, to understand what the requirements, what the facts need to be filed by complainants, what the responses should be filed by defenses, and so on. So for the whole picture, how the domain names disputes are resolved, it's very interesting to read some of this decision on the website. You can find them by any year, by any arbitrator, by any country. So the search conditions are very convenient on this website. Filing of complaint to the WIPO Arbitration Mediation Center. Complaint and response to the complaint. So the response should be filed by the respondent, filed to Arbitration Mediation Center online, and has a certain form. So you cannot file the complaint not matching with the form indicated on the website of the WIPO. It should be in certain form. It should contain some facts, some information, some data from complainant regarding domain names and so on. I will talk later about it in this presentation. Right for filing complaint has any person or organization who considers that the rights were infringed. So the trademark owner, even the license, who has a license from the trademark owner, also has a right to file this complaint. Complainant may concern few domain names, so not one, but there is a condition that domain names should be registered by the same registrant. So, for example, and we have so many cases, such cases when the one registrant register, for example, 10, 20 domain names with use of well-known trademarks. The whole corresponding with the center is in electronic form. So you don't need to send any mail, any documents in original, any notarial, only in electronic form. So we received the case, the whole case, for example, on 500 pages, only in electronic form. So there are registered in the some division of WIPO online, and we have an access to all these materials during we are writing our decision. Filing our opposition against the complaint by the respondent. So opposition, it is also the response, 20 calendar days from the date of administration proceeding commencement. Sometimes the respondents filed the responses and filed the opposition, but I think that it's quite rarely in our reality, because the respondents are usually just natural person who has an intent to get some profit and doesn't want to participate in this proceeding. Language of proceeding normally is the language of the relevant registration agreement. So sometimes there are some situations that when the registration agreement is in, for example, Chinese language, the domain name is in Latin script, not in Chinese. And for example, the complaint may ask the arbitrator to has the administrative proceeding, for example, in English. So the administrative panel has the discretion to designate a different language, taking into consideration the circumstances of the case. So if we are talking about that the complaint can be English company or person, American, and so on, or even Ukrainian, the language of the documentation. So I'm talking about if there is any burden of proof by complainant. So whether the complainant should present all documents, for example, in translation from Chinese to English, or he has already all these documents in English. So we usually takes access the request of the complainant and has the administrative proceeding in English. So we have such right to decide in which language we decide the case in each case. But normally, and there is a rule that the language of this proceeding will be the same as a registration agreement. So when you register the domain name. Just 1 second. Right. So more precisely, what is it, the complaint to the WIPO Arbitration Mediation Center? Which information, which data should it contain? The complaint included any annexes shall be submitted in electronic form and shall contain some concrete information, such as the contact details of the complainant, any information that can be known to complain about the registrant and the respondents, the grounds on which the complainant is made. There are three elements. They are the most important for filing the complaint to the center. Why? I should explain that this, without any of this element, the complaint can be accepted. So if a complainant, for example, cannot indicate some information referred to one of this element, the complainant will be denied by arbitrator. So we are talking about the first of all, the manner in which the domain name is identical or confusingly similar to trademark or service mark in which the complainant has rights. So the complainant should have rights in this trademark, and of course the domain name should be similar or identical, of course. So it is the first very important condition on which the complainant should be filed. The second one is why the respondent should be considered as having no rights or legitimate interest. So whether under these elements we are looking for whether the respondent has any rights, any registered rights in trademark, whether the respondent uses this trademark or used before or prepared for use, and so on. So any rights or any legitimate interests that can be indicated in this domain name by respondent. The third one is why the domain name should be considered as having been registered and being used in bad faith. So the bad faith is obligatory requirement for illegal registration of domain name. Why? Because we are talking about cybersporting, we are talking about illegal activity. So the bad faith is, I think, the most important in this illegal activity, in this illegal registration of domain name. So if the complainant cannot prove bad faith, it is 99% that the complaint will be denied by the arbitrator. So specification of the remedies sought should be also indicated in complaint. I will be talking about it later. There are two possible remedies under this proceeding, either to transfer the domain name or to cancel the domain name. So it depends on what the complainant requests from the center to do. Also, the parties not only complained but the respondent, if he is filing any response, should indicate any other legal proceeding that either have been commenced or terminated or ended with or relating to any of the dispute domain names. So it's very important to remember about this requirement, because if any of the party doesn't indicate that they have this litigation in process or terminated or already decided, it may be the ground for invalidation of the decision of the WIPO center. Also, the complainant should file the statement that with respect to any challenges to a decision in the administrative proceeding, canceling or transferring the domain name to the jurisdiction of the courts. So, for example, in Ukraine, the complainant signed the declaration that they accepted the jurisdiction of the Ukrainian courts. So we're not talking about the appeal to this decision by the WIPO Center, but in case of any misunderstandings or in case of any party doesn't is not satisfied by this decision, they should inform the WIPO Center that they want to file initiate a litigation, for example, in the Ukrainian court, and therefore the enforcement of the decision of the WIPO Center will be terminated for some period. Who are the WIPO domain name panelists? So we are arbitrator. We called ourselves right panelists in the WIPO Center. In our usual life, we call us arbitrators, international arbitrators who resolve the cases. We are the persons who have been selected on the basis of our well-established reputation. Of course, we should have no conflict of interest. For example, sometimes we have the situation when the complainants are our clients or our former clients or our opponents. So we should have no any conflict of interest, and we sign special declaration and some special statements, and we state that we have no conflict of interest and we are impartial. These panelists selected by the WIPO Center based on their very good how to say, very good summary and experience in the intellectual property. The panelist can be the person who has no less than 15 years experience in intellectual property law. The list of panelists are available also on the WIPO website. So there are now we are 400 panelists from over 50 countries. For example, in Ukraine, we have 2 international and 4 Ukrainian domain zone panelists. So 400 is not so many, but it's not so less, I think, for deciding the WIPO cases. 400 panelists are for all over the world. So we decide all cases from all jurisdiction in any language. So the panelists, for example, I can write the decision in English, in Russian, or in Ukrainian. Also, my colleague, for example, from Chile or from Argentina can, or from Spain, may decide, may resolve the decision in Spain or in English or in any language if they know it. The independent panel is appointed after the filing of the response within 5 or 15 days, depending on number of panelists. Who decide who will be the panelist only the WIPO Center. So the parties doesn't have any right to decide who will be the panelist if we are talking about the single panelist. If the parties decide that the case should be resolved by, for example, 3 panelists, they have an impact. They can indicate to the center that, for example, they want Maria Koval will be the presiding panelist in this case, and the defendant has the right to elect some of my colleagues for the second and the third panelist in the case. Panelists shall be impartial and independent, as I said. So we are talking about no conflict of interests. We signed some declaration. If we know or should have known, or we may know some circumstances that giving rise to justifiable doubt as to panelist impartial independence, we should indicate it. So we have obligatory requirement in the declaration. If some facts may be revealed after the decision is issued, it may be also the ground for invalidation of the decision. Compulsory elements for proving in the administrative proceeding, as I said, in the process, as I said in the last slide about the data which should be indicated as the complainant, we are talking about 3 elements. Each of them should be indicated in the complaint, should be proved by the complainant, and should be opposed by the defendant if he has or she has any facts, any evidences against this complaint. So the first one, disputed domain name is identical, confusing, and similar to a trademark. The respondent doesn't have any right or legitimate interest in this domain name, and the disputed domain name has been registered and is being used in bad faith. The third element is very interesting. So we are talking about not only about registered and not only about that somebody cyber squatted this domain name, but this domain name should be also used in bad faith. For example, in Ukraine, we we have some amendments in this international proceeding, and we should prove either registration, either bad faith registration or bad faith use. So we should not prove the both element of this third element. As I already said, without these elements, the complainant should not file any complaint. There will be no success. So before the filing the complainant, for example, you like representative of the complainant or your clients, your future clients and potential clients should understand all risks before filing, because the WIPO center will not take off any money after the filing of the complaint. So the money will not come back. So you should understand that you can prove that the disputed domain name is identical, confusing, or similar, that the respondent doesn't have any rights, and that the disputed domain name registered and is being used in bad faith. I should notice that for prove these elements, you should not have any forensic examination, any legal opinion from any special lawyers or professors. You should only indicate in the complaint that the domain name is, for example, confusing or similar, in which part, why you consider so, and why this domain name should be, for example, cancelled on this ground. This refer to also the second and the third element. The complainant should indicate all known to him information and data with any documentary or written or electronic evidences. So any possible documents will be very helpful in proof this in proof of these elements. I should mention that we, like the panelists, have no right to find any additional documents, any additional evidences in favor of either complainant or of the respondent. So this is a burden of proof of the complainant when he files a complaint to the center. Examples of registration of confusion with similar domain names. So according to the general use, if the domain name includes a trademark in its entirety, or if the dominant feature of the trademark is recognizable in the domain name is considered confusing or similar to trademark. So, for example, somebody registered Facebook.nl, Netherlands, for example. So it is obvious that the Facebook trademark Facebook has been used in this domain name, and we're talking about the obvious case when the domain name is identical to trademark. I indicated some examples for your understanding which domain names are used the most of all in this domain name. So in which in respect of which domain names this procedure is doing. First of all, it's the addition of other terms. Any terms can be added to the trademark in domain names. I indicated some examples for Electrolux product, L'Oreal Bank, and so on. It's very common situation which cybersquatters used in registration of illegally registered domain names. It's obvious in this, for example, if we are talking about first example, it's obvious that the domain name is confusing or similar to trademark because, for example, trademark Electrolux in the first domain name is recognizable, obviously recognizable in the domain name. So the product doesn't take into consideration in this case, and it is a simple descriptive term which has been added to a well-known trademark. The second example, we have many cases when the domain name consists of a misspelling of the complainant's trademark. It's so-called typo squatting. So this term means that, for example, you can find, you want to find Electrolux official website, and you can see such Electrolux with 200 domain name, and of course you may not notice this mistake, and cybersquatters used it's very good in their domain names, and it's very bad for trademark owners if, for example, the respondent or the illegally registered the cyber squatter uses this domain name for website, for example, with malware software, or for the website for the competitors of the trademark owner. It's very bad because the traffic of the internet users forwarded to this website, and of course it's very bad for reputation, for example, for trademark owners. The third example is the domain name consists of the complainant's mark plus a third-party trademark. It's not so common situation for our domain name disputes, but recently I decided some case in joining two trademarks. So one of them was complainants, and the second one was also very well trademark. So they joined them in one domain name. The first example of domain name consists or is comprised of a translation or transliteration of trademark. It's a rather common situation if you're talking about, for example, Chinese market. They use their language in the domain names for misleading the internet using. So it may be either translation or transliteration of a trademark, which is not so obvious, for example, for internet users from another countries, but there are some cases where such domain names were used. Evidences of respondents' lack of rights or legitimate interest. So how the complainant should prove or may prove that the respondent has no rights or legitimate interest. There are three some kind of rules which the complainant may use for filing his complaint. So the respondent didn't use or didn't show any demonstrable preparation to use the domain name or name corresponding to the domain name in connection with a bona fide offering of goods or services. So this is a situation when, for example, somebody, even distributors, even official representatives registered the domain name in their name illegally without any permit of the trademark owner, and they use, for example, even for official goods of trademark owner. But the trademark owner in such cases always not sure that the goods or services which is presented for sale are original. So even if it is the official distributor or official representative, it will not be considered as a bona fide offering of goods and services. The second one is the respondent has been commonly known by the domain name. So there were some interesting situations when the respondent, for example, began to use trademark of the original trademark owner before probably registration of the trademark or even after, but in some cases the respondent may be very famous by this trademark, and in this case the trademark owner, so I mean the complainant, will have some difficulties to prove this element, but in general the respondents don't have any information regarding their famous or their well-known activity under illegally registered domain name. The third one is the respondent is making a legitimate, non-commercial or fair use of the domain name. So if the respondent, for example, uses their website for critics, it will not be considered as not bona fide. It will considered as good faith use of this domain name, and in this situation, complainant will not have any, I think, chances to prove that the respondent is a cyber squatter. So the domain name should be used non-commercial or commercial. It depends on which facts the complainants can or should prove, or which facts or evidences the respondent may file to the center. Non-exclusive scenarios which constitute evidences of the respondent bad faith. When we are talking of the bad faith, there are some four, I think, initial rules for understanding in which situation the domain name may be registered in bad faith. First of all, that the respondent registered or has acquired the domain name primarily for the purpose of selling, renting, or otherwise transferring the domain name registration to the complainant. So some of my complainants, in some of my cases, the respondent, for example, suggested to complainant some time ago, sometime prior to filing the complainant, suggested to sell the domain name, for example, $200 or $2,000 or even $20,000. So if the complainant has any mention from the respondent that it suggested to sell the domain name to him, he should present it to the center that there was such fact that the respondent registered this domain name for the only purpose of selling. So it depends on situation, but in general, it is obvious situation when the respondent suggests to sell this domain name to the complainant. So it's not so difficult to prove it by complainant. The second one is the respondent has registered the domain name in order to prevent the owner of the trademark or service mark from reflecting the mark in a corresponding domain name. For example, some respondents registered domain names with use of well-known trademarks in many I would say in many domain zones, or in some in one domain zone, but with different paths with these trademarks. So it's obvious that the respondent registered this domain name for not giving any possibility for the complaint to access the market. It refers to, I think, especially refers to the situation when, for example, some foreign company wants to have an access to any other foreign market, and in this situation, they usually and mostly has a situation where they cannot register any domain names because they are occupied by some cyber squad. The third one is the respondent has registered the domain name primarily for the purpose of disrupting the business of a competitor. We are talking about the situations where the domain under the disputed domain names are located some website with, for example, goods of the competitor of the trademark owner. So the usual situation in our cases, and it's obvious that in this case the complainant can talk about that the respondent acted illegally because he wanted to disrupt in the business of the trademark owner. The first one, by using the domain name, the respondent has intentionally attempted to attract for commercial gain internet users to his website or other online location by creating a likelihood of confusion. So, for example, when we're talking about well-known trademarks, I think it's obvious that the respondents, cyber squatters, registered the domain names for the only purpose for attracting the internet users to their website by using the reputation of the well-known trademark owner. So in the situation when we are talking about well-known trademarks, it's obvious that the only purpose of the respondent was to attract for commercial gains the internet users by using the well-known trademarks. So the cost of domain names dispute resolution are different. It depends on number of domain names in the complaint, and it depends of the number of the panelists who resolving the case. If in the complaints indicated from 1 to 5 domain names, the cost will be 1,500. Panelist has $1,000. WIPO center takes 500. From 6 to 10, it's $2,000. more than 10 as agreed with the center, but in practice there will be no more than 5 or 10,000 dollars. If the dispute is resolved by 3 panelists, the price will be higher. From 1 to 5 domain names, it will be 4,000. From 6 to 10, it will be 5,000. And more than 10, again, agreed with the center. The costs may be high, of course, in comparison with one panelist, but again, not higher than, I think, $15,000 if you're talking about, for example, 20 domain names or even 50 domain names. So there are some cases where there were 50 domain names and even 100 domain names in one complaint in one case. So the costs will be higher than up to 5 domain names in one complaint. There is a final price, no any other expenses, no any other fees should be paid by the parties. So it's very convenient that that the complainant pays this sum and doesn't think about anything more because this price is final. And it's very convenient that no additional fees, for example, for lawyers or for the barristers should be paid by the parties. Remedies under UDRP, I already mentioned it. The remedies available to a complainant to any proceeding. So the complainant may ask the administrative panel either to cancel the domain name or to transfer the domain name registration to the complainant. In practice, I think that I'm sure even that the transfer of a domain name registration is 99% of all cases. I think it's obvious why, because in case when we are canceling domain name, any other person in the next day has a possibility to register this domain name legally again. So for the interest of the complainant, they usually ask to transfer domain name registration to them, and they have all legally registered domain name registration under their control. Of course, it takes some costs for renewal, for example, these domain names, but we always advise our client to ask to transfer domain name, not to cancel. But some percent of our decisions consist some request to cancel a domain name. It is very important to understand and to remember that the center does not resolve any matter of compensation for damage and legal costs connected with domain name disputes. So while filing the complaint, you cannot request any compensation, any legal costs even for this proceeding or any other proceeding. The center only resolves the case and only decides either to cancel or to transfer of a domain name. So if parties want to access to obtain the compensation or any legal costs, they should go to the court, and on the ground of this WIPO arbitration and mediation center decision, they may request the court or through the court the other party to pay them some compensation. Examples of the decided domain names disputes. As you can see, it's well-known companies where the complaints, Wikimedia Foundation, the domain name sellwikipedia.org. Besides, it's my decision. I decided to transfer the disputed domain name to the complaint. It was quite interesting decision and quite interesting case because the respondent tried to argue that they promote the Wikipedia trademark and they promote their activity. They had the respondent had some interesting website under this domain name. It refers to some information, general information, and they try to argue that they have a rights in it, and they did not infringe anything. But nevertheless, they had no, of course, they had no evidences that they have any relation to Wikipedia trademark, they have any rights or something like that. The second one is WhatsApp. As you can see, it is an example of joining some trademarks in one domain names, Telegram group, WhatsApp groups.com. So there are many of such kind of domain illegally registered domain name. The decision was to cancel the disputed domain name because the complainant asked to cancel. It's obvious that the WhatsApp doesn't need any dispute domain name with Telegram group trademark, so it asked to cancel. KPMG also well-known trademark. One second. The decision was to transfer the disputed domain name to complaint. You can see also interesting representation of this domain name KPMG group.com. So in this situation, the defendant, the cyber squatter, used KPMG with a descriptive term. But it's obvious that KPMG trademark is recognizable in it in this domain name. So there are other examples of obvious decision, obvious cases where of course the trademark owners has all rights in their trademarks and has all rights to take their illegally registered domain names by themselves. I already noticed that the right of the complainant ask either to transfer or to cancel the domain names. It depends on situation whether the trademark owner is interested in continuation, for example, use of this domain name or not. But in almost in 100%, we advise our client to ask indeed to transfer the domain name to them. Thank you very much for your attention. I think that it should be very helpful, and especially for me, it was very interesting sphere when I began my practice in intellectual property, and I enjoyed this procedure and uniform dispute resolution procedure very much. And I read many decisions before I became the arbitrator, and I think and I believe that you also can be also sometimes the arbitrator or the panelist in this procedure. If you have any question, I will be glad to respond to any.
Thank you so much, Maria, for the beautiful presentation. Personally, I've learned a lot, and it's just like I was present in the last session, and some of the things that were said here, it's just as if you're just saying them again, like I've not had them before. Thank you so much. I'll be going back to watch and listen to the presentation again. Thank you so much. So I'll be calling on the mentees to ask their questions now. I have a question first from Juliana. She said, under the elements in your presentation, the third point says the disputed name has been bad faith. Do you mean trademark registration or domain name registration?
It's a question to me.
Yes, ma'am. Yes.
Can you please repeat, because there's some problems with connection and I didn't hear you very well.
Okay. Under the elements in your presentation, can you hear me now?
Yes.
Under the elements in your presentation, the third point says the disputed name has been registered and is being used in bad faith. Do you mean trademark registration or domain name registration?
I mean, of course, domain name registration.
Okay, thank you.
But if you have any evidences filed by any parties that the trademark registration was also in bad faith, it will be also an argument in this administrative procedure. But first of all, of course, we are talking about registration bad faith of domain name.
Okay, thank you. Our mentee will be asking their questions. Then you would answer them. That's after every one of them has asked the questions. So Tola, are you here?
Yes, I'm here. Good evening.
Okay.
Can you hear me?
Yes, I can.
Yes. Because of my network, I do not really I don't know if she mentioned this, but my question is about domain privacy. Domain privacy, does it mean it adds another layer of protection to your domain name, different from the general domain name? Because I was reading about it and I stumbled upon that and domain privacy, but I did not really understand what it entails. So yeah, that is my question.
What do you mean under domain privacy?
I did not get what you said.
What do you mean under the term domain privacy? You mean that
While I was reading about domain name and all of that, I stumbled upon that term domain privacy, but it was not really clear, so I thought to ask.
I think that you mean the domain privacy is that any data, any information, any contact details regarding the registrant are not seen to the parties. So you cannot find any of this information, for example, through the WHOIS service. So we're talking about the registrant in anonymous in many cases. We're not talking about the privacy or I think like GDPR, if you know, we are talking about that the natural person has no obvious contact details in this system and these services. So we cannot find them so easy, and we ask each time the WIPO center to inform us these contact details. But they are covered. So they are private and they are protected by privacy laws.
All right,
Then thank you so much.
So the rest mentees will be asking their question all at once, then after which you would answer them after they've all asked the questions. So I'll call on Rebecca to ask her question. Is Rebecca here?
Yes, I'm here. Good evening.
Good evening.
Thank you, Marakova. Thank you for the presentation. I've actually been finding arbitration, domain name arbitration, very interesting. I'm subscribed to the mailing list, so I get notifications on sessions that are completed. Thank you for today's lecture. I learned a lot. My question is this: you taught it briefly during your presentation and also answered every other question I had, but I would just like to clarify this. So in a circumstance where a complainant's domain name is, first of all, there has to be a restriction of trademark like you pointed out. And what if the respondent in a particular case now has registered the domain name as a trademark in his own country, considering that trademark registration is mostly national? For example, your domain name is registered as a trademark in Nigeria, and another company similarly registered their domain name as a trademark, say, in the Netherlands, and both of them have a website running on the same trademark name. Now, the claimant, the complainant in the Netherlands, is bringing an action against the respondent under the WIPO arbitration program. So what's it going to be? Is there, how will this affect the requirements of legitimacy and bad faith?
I'm sorry, Rebecca, I can't hear you very well. Christina, probably you can help me if you understood the question, because the sound was very...
Okay, I didn't really get, the sound is also faulty here. Maybe she should type it on the chat box. Okay. Rebecca, can you do that? Yeah, so before then, let
you hear me better?
Call on Dawn. Okay, yes.
Okay, sorry about that. I said, considering the fact that
domain name disputes have to do with registered trademarks, and trademarks can be registered nationally, like in your different countries, and also internationally. So in circumstances where the complainant has registered his trademark, which he uses as his domain name in his own country, say in the Netherlands, and the respondent has done similarly in his own country, say in Nigeria, and neither of them have an international registration, and the complainant is bringing an action in the WIPO arbitration section against the respondent, how would the requirements of legitimate claim and bad faith affect this kind of circumstance, considering that both of them have substantial legal claims, at least in their own jurisdiction, and WIPO's arbitration center applies internationally?
Thank you for your question. I understand now. You see, there is no need to have any international registration. We are talking about even national registered trademark or even not registered trademark. So it depends from case to case when the complainant can prove then he has a right in this trademark. This trademark may be even not registered in any jurisdiction, not only, for example, in Netherlands or in Nigeria or anywhere. If the trademark owner uses its trademark throughout the world or even in one country, we are talking about the access of the internet now. So we can find any information from Nigeria or from America or from any country. So it's obvious that the cybersquatters may use the well-known trademark in one country for registration, for example, in another country. So it's like analogy with trademark registration when the trademark owner doesn't have any registration in another country. But there were some situations in this procedure. For example, complainant filed the complaint, and he considers that his trademark is well known in the world or in some country, and the respondent, due to his use the same or identical or similar or confusingly similar trademark in another country, argues that he has a right for trademark. It depends on the case. There were some complicated cases when we, like the panelists, cannot resolve the case through this procedure, and we denied the complaint, and we indicate in the decision that the parties should go to the court. So there are some, it depends on jurisdiction, of course, but through the court, because we cannot decide complicated cases when we are talking about interest and legitimate interest of both parties. So the situations when the complainant and the respondent has identical or equal legitimate interest in domain name and in trademark. So it depends on, but just general rule that there is no barrier, there is no bar for registration of trademarks in one country, for filing this complaint in respect of a domain name, for example, in another country. So this procedure, I mean domain names and Uniform Dispute Resolution Proceedings, called UDRP, was established and was officially established by the WIPO, namely for such situation when the complainant or the trademark owners don't want to file any separate litigations in each country against the respondent, for example. I hope that I answer your question, if I understood you correctly.
Yes, you did. Thank you very much.
Thank you, Maria. So, Dawn, are you around to ask your question? Dawn. Let me quickly ask a question from Maggie. She said, how many cases per year does WIPO receive, and in which member state does cases derive from? Did you get that? Maria?
Which cases?
How many cases per average in a year does WIPO receive?
Average
in
per year. Average in a year, yes?
Yeah, like how many cases per average in a year does WIPO receive? And in which member state does cases derive from more?
The top countries of the complainants are America, United States of America, France, I think Canada. So where the well-known trademark owner is located? I don't remember exactly, but I remember for sure that the United States is the first state who files the most number of the complaints. Regarding the numbers of the cases, in average, it's from 3,400 up to 4,500, something like that.
Okay, all right, thank you. Dawn, is Dawn around? Is Dawn around?
Can you hear me?
Yes.
Yes.
My question is, what is the procedure for and what kind of domain name disputes are resolved by WIPO?
What do you mean? What kind of domain names? Any kind of domain name can be resolved in respect of domain zones like general.com, net.org, and so on, and in respect of 75 country code domain, for example, Spain, Ukraine, Canada, Australia, and many others. No Nigeria, I checked it.
All right, thank you so much, Maria. I have a question to ask. In the presentation, you talked about the requirement for one to be in the panelist, and you said one should be impartial. You talked about experience. You said not less than 15 years experience as well. I want to know what other qualifications, like academic qualifications. Just being a lawyer is enough. What other academic qualifications should one seek to attain to be a domain name, to be a panelist?
It is possible to be either a lawyer in intellectual property or, for example, trademark attorney. If the trademark attorney is not a lawyer, it will not be a barrier to become the panelist. So you need to work in IP law, no more or less 15 years, and you, of course, you should show it to the WIPO center before they elect the arbitrators. But now this procedure is, I think, closed, and they sometimes searches for somebody if we are talking about country code domain, but in general, it should be experienced and highly professional lawyer with some recommendation, with some proved experience, but not obligatory lawyer.
Okay, thank you so much. Thank you so much for the beautiful presentations. Thank you for answering all of our questions. We are so grateful to you. And we have Mr. Marks and Mr. Folari here. I wouldn't know if they have something to say to you. Mr. Marks and Mr. Folari.
They are relaxing now, so we should not.
Yeah. Okay, I hope you can hear me.
Yes.
Can you hear me now?
Yes.
Yes.
Okay, thank you so much, Maria. That was a very excellent presentation. Thank you for covering the entire process, from start to finish of a domain name dispute resolution proceedings. So for me, I benefited a lot from that. It's something I've known before, but you made it very practical. So thank you. Just to add that the Nigerian country code top level domain, that's .ng, has a framework for domain name dispute resolution. But the last I know, it's supposed to be managed by an organization called the Nigerian Internet Registration Association.
Yes.
Registration Association, yes. But from the last I know, I attended their annual meeting in 2019. That procedure has still not been set up till date. So if you have a dispute with a Nigerian country code level domain, that's .ng. At the moment, they usually refer and advise you to go to court to resolve in court. So unfortunately, we don't have something as fast and as efficient as the WIPO domain UDPR in Nigeria yet, but we're hoping something happens and that changes soon. So we're still waiting for that. I don't know, Mr. Folari may know if they have set up, but the last I knew they are not set up. So I don't know if he's aware if they have set that system up by now. So thank you very much, Maria, again for a very wonderful.
I have a question to you. Do you have many illegally registered domain names in Nigeria now?
Sorry, I didn't get your question.
Do you have now many illegally registered domain names with your country code, with NG? I mean.
Well, generally, the .ng code itself has not, I mean, as at the last statistics I knew, I think total registrations in Nigeria is not even up to 50,000 in terms of the .ng domain across all the different subdomains. So we have .gov.ng for government, and then .edu for educational institutions.ng and all, but across the entire .ng system, we don't have maybe more than 50,000 domains registered. So we don't have too many cases yet of disputes of cyber squatting on the .ng system really that I know of yet. It's not something too popular, but we have a lot of domain name cases from Nigeria on .com. For instance, at least I know of up to 6 Nigerian cases that have gone to the WIPO UDPR proceedings, and it's been a mixed bag. Sometimes the Nigerian defendant has prevailed. Sometimes the Nigerian has gone there as a complainant and has also prevailed, but not too many in the .ng, the country code level for Nigeria.
Okay, thank you also.
I hope that answers your question. Thank you.
Thank you. I was glad to see you and to hear you.
Yeah, I don't know if Mr. Folari is around if he has anything to say.
Okay, thank you very much, Maria, for that very illuminating presentation. I mean, you've covered the field, and I must say, you know, it actually was very, very. You covered the field, you know, and I think Max has made. I was going to make a reference to the Nigerian situation, but you know, Max has very eloquently covered that as well. I don't think the NERA rules, the NERA rules are in operation. I don't think they're operative yet, as far as I know, as at 2021. I think there were some delays as a result of COVID in 2020, and so the rules or the procedure hadn't gone into effect. And so I'm not very certain. Just 1 second, sir. I'm not very certain if that has gone, you know, live, but it would be a good idea, you know, to have that, to have these disputes resolved by mediation, because the process of using litigation to resolve the disputes, you know, can be quite expensive, you know, time consuming, and so on and so forth, and the damage would have been done to a very large extent, I think. But now NERA requires some basic compliance documentation from registrars before certain types of names are registered. So if you're trying to register, about 3 years ago, you could register almost any name with a .gov.ng, which is a reference to like a government parastatal or agency. But now, if you're doing any registration, you know, that has the imprimatur or that appears to have some kind of government participation, you'll be required to present evidence of either some kind of approval or registration with a government agency. So to some degree, NERA is trying, at least at the compliance, documentary compliance level prior to registration, that's with local registrars now, to achieve some kind of, or at least to reduce cyber squatting and you know, duplication of domain names, at least as far as the .ng domain is concerned.
Mm-hmm.
Yes, so thank you very much once again, Maria. I hope that makes some sense.
Yes, thank you for your feedback.
Thank you very much, Maria, for this presentation. I've actually learned a lot. Thank you so much for saying yes. Thank you for coming. I really appreciate it. Thank you so much.
Yes, you're welcome. I hope that it was helpful and interesting for your mentees, and some interesting facts from this procedure can be very useful, I think, in their future professional activity. So I wish all of you good luck, and to act under this procedure with your clients, and to read more about it, because it's very interesting part of intellectual property law.
Okay, thank you so much, Maria. It will be very useful to us. I'm very sure of that.
Okay, I'm glad to hear it.
Okay, Christina, over to you.
All right, thank you so much. Thank you so much, Maria, for the presentation and for answering all of our questions as well. I don't know if you have anything to say to us before you leave, like a word of
I
advice.
wish you a nice weekend and very good starting of the summer in the sphere of intellectual property. And that all of us will have a possibility to meet on conferences and forum offline. It might the most needed now. I like a dream. So I wish all of us that we will do it finally.
Thank you so much. Thank you so much. Do have a beautiful and pleasant weekend. Bye.
Yeah, thank you very much. Bye-bye to all.
All right, bye.
Okay, thank you very much, Christina. Please, Mr. Folarin and Mr. Max. So I'm not sure if we should also have two presentations from two of the mentees, or if we should leave it for next week.
Okay, I'm sure I could take one because I have a flight. I'm just getting to the airport. So I'm sure maybe it will take me another 15, 20 minutes to board. So I don't mind if we carry on and at least see to what extent I can get before I have to switch off my phone.
Okay, so I think last week Adetola submitted her assignment, and I think Sewese, I'm not so sure. Christina, you have the names, right, of the two of them?
Yes,
so any of them can present.
Yes. If Tola is ready, she can go ahead and make her presentation. Tola.
Yes, good evening. Can you hear me?
Yes, I can.
Okay, yes. So first
Tola.
yes, sorry. My name is Adetola Leomi. I'm a Part 3 law student, and my article topic for this week is
Tola.
Space law and intellectual property is undeniably important. Yeah, can you hear me?
Yes, but your voice is breaking. You can go ahead.
Okay. I don't know if you got my article topic.
Space law and intellectual property, right?
Yes. So to start with, intellectual property is undeniably important for space exploration, as we know, research and its growth. Now, certain disputes, however, continue to persist. Now, I mentioned some of those issues that are involved with intellectual property rights in space, in regards to the space. First is one of the most frequently discussed questions in relation to inventions made and or used in space is the applicability of national or regional patent law in space. That is, who owns what? In a given case, which nation's rule applies, and if they can be followed at all. That's the first issue. Now, the second one I mentioned is the interpretation of Article 5 of the Paris Convention on Industrial Property, which establishes certain limits on the exclusive privileges conferred by a patent in the public interest in order to ensure freedom of transport. I just want to quickly run through, so I'm really sorry if this is too fast in a way.
Tola?
Now, best practices for intellectual property plan. That's the first thing they should protect IP, and that's very important. I also mentioned the case of Mark Zuckerberg and some other pioneer founders of what we know as Facebook. The third one, companies must protect their IP using an international mindset. And the last one, I mentioned in conclusion that every business has an opportunity to innovate and create better technology because it owns exclusive rights to its products, which means no one else can use them. So intellectual property rights are the only way that such exclusive rights can be given. As a result, IPR laws must be brought in line with space laws for the overall good of space exploration. And that's the end of my conclusion. I'm sorry for rushing through it. Really sorry about that, but I'm not too sure about my network, so I just had to. So yeah. Thank you, Christina.
Thank you, you're welcome. So let's, Mr. Marks can speak on our presentation if he's still around. Mr. Marks? Let's call on Mr. Folarin to speak on the presentation.
Hello, can you hear me?
Yes, I can.
Hello. Okay.
Hello, I can hear you.
I think that was a very it was a very short and sweet presentation. It would have. I actually was quite interested to find out how it will go, especially looking at space law and IP. Unfortunately, I think there must have been a network issue at my end because I didn't get to hear most of the presentation. But just off the top of my head, I followed like the US development of space law as a subject matter, especially in the US, in the creation of Space Force and recent UFO sightings, the classification of documents, in the UK and in the US by the Department of Justice, Department of Defense. And intellectual property does play a very huge role, in these areas, especially around space technology, patents, industrial designs to some degree. And by space technology, I mean the technology that astronauts use to survive, or space explorers, astronauts use to survive out there, the technology that is used to man the, what do you call them now, the remote controlled vehicles, so the technology used to capture what's it called, samples, shots from space and all of that. I'm also interested in issues surrounding ownership of images, ownership of dark things. And let's assume that an astronaut in space were to write a poem, what law would regulate that poem? Would it be space law? That's just a joke, of course. The problem, I'm guessing that it would be the private international law of the astronaut. So if it's German, it will be German law. If it's Nigerian, it will be Nigerian law. And so I'm interested in some of these areas, and how intellectual property law, intersects or interacts with the space war, as it were. At the moment, most Nigerians are just thinking of how to get by, how to eat the next meal. And so space is far, 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 is way off our radar. But I'm not sure if some of us are aware. You can Google it. I think there were reports earlier this week about a UFO sighting of what is believed to be an unmanned aeronautic vehicle that was doing maneuvers, like vertical and horizontal maneuvers, that defy the laws of physics and defy all known technology. And these are issues that agitate the mind when you're talking about, okay, what's the next level in technology? What's the next level in terms of space tech and so on? These are issues that agitate, one's mind. And for me, the question is, how can Nigeria plug into these realities? Because another thing that we don't really do here is use the patent system as a source of information. The patent system provides a trade-off: protection in exchange for disclosure.
Sorry, is it my internet? Can we hear Mr. Folarin?
Okay. No, I can hear him. I guess it's the network from his end.
Okay, so while we are waiting for him, I'll just say that I think that we should always look at all these things also from the intersection between IP and all these areas. So if we're talking about space law, we're still talking about the simple forms of IP that we know about. So we know about copyrights. Copyright can protect the manuals of things that are created for the space travel and all that. We have patents. Patents will protect the technologies that are new and all that. We have trademark. Trademark will protect the brand names and the logos and all that of things that are created for space travel and all that. We have industrial design. Industrial design will protect the form and the shape of the things that are being used to travel to space and all that. Then there are some other things that might still come into play, like a non-disclosure agreement for maybe some technologies and know-hows that are used. And you also talk about different things. So when looking at any law, I think we still have to look at the basic forms of IP that we know and then see how it comes into what we are doing. Same with contracts and all that. So thank you very much. Maybe Mr. Marks can talk while we are waiting for. Okay, Mr.
Folarin is around. Can you hear me now?
Thank you. Yeah.
Now, so apologies. I was just checking in for my flight. That's why I couldn't speak earlier. Hello.
We can hear you.
Oh, okay. Yeah. So that was a very good presentation. Incidentally, my current area of interest at the moment is actually on space law. So I recently enrolled for a space policy class. And I love the selection of the topic, making a relation, because whether I like it or not, space has become the next frontier. It's become a very important place. And I'll just throw, I didn't hear the presentation fully, but there's actually a very interesting IP issue currently in space. Now, when it comes to navigating in space, it's not like regular flying. There is a lot that goes into how you fly from one destination in space to another. So for instance, flying from the Earth to the Moon involves a lot of procedures and processes, and there's an efficient way to do it and a less efficient way to do it. So at the moment, there's been some controversy that NASA had patented a particular method of getting from Earth to the space, a particular, travel procedures and protocols involved with that. So that has been some form of controversy. Of course, another controversy also has been the impact of some of the industrial designs, or in America called design patents, that SpaceX, that is Elon Musk's company, has in respect to some of their space vessels. And then there's talk that in China, they have copied the exact designs for his spaceship. So that's also a brewing challenge where people are wondering, look, when it comes to space, should they allow normal IP law operate? Because when it comes to space, we are talking about efficiency for the benefit of all of mankind. So should one person be able to monopolize a design or a patent on a process of how to work, work processes in space that will prevent others from benefiting from that? So that's, an interesting area. Of course, the basic issue of property in space. There's a treaty called the Outer Space Treaty that governs, how nations exploit and explore space. That says, look, space should be, nobody should claim ownership of space. It should be for the benefit of all of mankind. So the question is, like Mr. Folarin said, an astronaut writes a poem while it's in space. Should that be protected, or should it be left in the public domain for all of mankind to benefit? Of course, that would be easier to resolve, like you said, that the private international law of the astronaut could easily settle that. But when it comes to patents, designs, that's where it becomes a little bit tricky, because these are about technical processes that will benefit all of mankind. Should we allow one person monopolize it? So that becomes an interesting area of discussion and further research. So thanks so much for the presentation, and back to you, Juliana.
Thank you so much, Mr. Marks. Mr. Folarin can unmute himself to continue.
No, sorry, the wind was taken out of my sails. But yeah, I think I heard both Juliana and Max, and I agree 1000% with the both of them. So, I feel this conversation should explore some of these issues. Of course, there are ethical issues as well, as Max has mentioned. So yeah, it's good that we're having, we're considering these points. Now, I don't know whether we should. I mean, space is here, so we should start having some kind of policy. But the question is, would it not happen? Would it not turn to the situation we have in the engineering unit, where the students of mechanical engineering would only see turbines in textbooks and would never get to see a turbine, in real life until after he or she, has graduated. So the question as to, how do we start to design and draft policy when we've not even, those who are going to space by way of Edo or Bini line, those who fly at night, we don't have a policy for them yet, and we now start. But I do agree with Max that it's something we should start taking seriously. I think NIGECOMSAT, I don't know, Max should know a little about this. NIGECOMSAT has been missing for some years now, or for a little while. The satellites, the NIGECOMSAT 1 and NIGECOMSAT 2. The first one, I think, has disintegrated. The second one has been missing for a while. Our space law jurisprudence, or the regulatory whatever is in total disarray. And you have companies jumping into space. So you have people like Zuckerberg, making bold steps to use satellites to provide to provide Wi-Fi to continents. You have people like Bill Gates, deciding to cover the sun over a part of the world. So I think there's a lot of space, no pun intended, for several conversations around IP in space. Thank you.
Thank you so much. I really don't understand what you mean by the Bini way to space. You say people follow Edo way or Bini way.
Some people use Bini way now when they are going
like
to
is there a
space.
road there?
I don't know. I think it's airborne.
Okay.
They found someone showed me a video of somebody who turned up at the Abuja International Airport, and the person was carrying a nylon bag. And they asked the person, "Where are you coming from?" And the person said, "I'm coming from Delta." And everybody, even the security people said, "This one I beg, I thought I had to go where she's going." So We too, we have our own space explorers. That's the point.
Okay. Thank you so much, sir. And the last person to present is Sewese. I don't know if she's ready. Sewese. Sewese. I can see you've unmuted yourself, but I can't hear you. Sewese. Hello? It seems your network is bad.
I can hear you.
Okay, please go ahead with your presentation.
Okay, thank you. Okay, so I'll be presenting briefly on intellectual property financing. So I'm taking a look at using intellectual property assets as bankable assets. Okay, can you hear me?
Yes, I can.
Okay, so I'll be going ahead. So I'll start briefly with what IP, that's intellectual property financing, means. So this is simply using IP rights or assets to gain access to credit facility. So it involves leveraging these assets in exchange for finance or loans from lending institutions. So this is just similar to the normal way of maybe assessing loans using collateral as security for the loans. So with this, we're looking at using IP assets as well to assess loans, especially in relation to startups and SMEs. So these assets, IP assets, are classified into formal and informal IP. So with the formal, we'll look at trademark, copyright, industrial designs are all under formal. Then informal, we have trade secrets, organizational knowledge, know-how, proprietary code, and so many others. Then broadly, we classify intellectual property rights or assets under intangible assets. So the tangible assets will refer to normal things like property, and other things that we can use as collateral for loans. But IP rights and IP assets are considered as intangible assets. So to assess financing, there are a lot of financing methods that can be used. I'll list some briefly. We have auctions. So auctioning is one way that you can assess finance with your IP assets. So some persons hold live events, some offline. So it enables persons sell their intangible assets faster, and then they are also able to create a market for potential buyers. Then another financing method is IP-backed loans. So with IP-backed loans, it's similar to the conventional method of using whatever you have as collateral as security for a loan. So, but in this case, you use your IP assets to obtain the loan. Then we have IP royal securitization. That's another financing method. So securitization is, it requires the IP owner to sell future IP related streams of income in exchange for a lump sum or lump payment. And then this will, one of the advantages of this financing method is it transfers the risk from the IP owner to the assets. So in terms of bankruptcy, the owner is shielded. And then, briefly, IP royal securitization and IP-backed loans are somewhat similar, but the difference between the two is with securitization, the owner sells. With IP-backed loans, the person is borrowing, but with securitization, the person sells future streams of income. Okay, so one other method is also IP sale and license back. So this one requires the owner of an IP asset to sell it, and then when it is sold, it is assigned to a back licensor, and then the licensor contracts it back to the owner again. So it's usually for a specified duration and for a specified fee or amount. So there's also a term that would allow the owner to be able to acquire the property at the end of the contract as well. So those are the various IP financing methods that we can use to acquire loans as well. So I also briefly look at the advantages involved in using IP assets to acquire loans. So one of those advantages is increased number of alternatives. So in addition to the traditional financing methods of using your tangible assets to acquire loans, you can also use IP assets to acquire loans. So it gives the borrower a lot of other options as well. And there's also a lower risk profile with regards to using your IP assets. So for instance, with the case of securitization, the obligation or the risk moves from the borrower to the assets in case of bankruptcy. So that's one other advantage. Then we also have lower execution costs in terms of when you have an IP asset that is consistently generating revenue, it results in a more attractive cash flow stream. Then we have higher returns on investment as well as another advantage. So for everything that has an advantage, you also have disadvantages. So some of the disadvantages rather of IP assets financing include possible loss of IP and liquidation of the company. Okay, so where there's a default in the loan, in repayment of the loan, it could lead to the loss of the assets, that's the IP asset, and then possible liquidation of the company as well. Then there's also difficulty in valuation of intangible assets. So a major requirement for using IP assets in order to assess finance is valuation. The assets must be valuable. So in terms of intangible assets like IP assets, valuation is usually very difficult. So it poses a more complex and probably a high risk for both the borrower and the capital provider as well. Then there's also difficulty in liquidation of the intangible assets as well. So when it comes to tangible assets, they are more easier to liquidate because there's a smaller scale and all of that. But when it has to do with intangible assets, it's kind of difficult. Sorry, I'm a bit fast. So I go to the conclusion now. So from the foregoing, it has been established that IP assets are indeed bankable. So we can use them to assess loans, especially for startups and SMEs. So IP assets can be fully utilized either solely as intangible assets or as an additional collateral to tangible assets to assess financing options. So, but the problem is for these assets to be economically beneficial to the owners, they must be valuable. I think I mentioned that earlier. And then another issue is most jurisdictions do not offer adequate legal means for this for IP financing. That's for the use of IP assets to acquire financing and all. I was in a forum recently. I think I would like the view of Mr. Polarin and Mr. Marks on this. I don't know whether it has been implemented. Someone mentioned that the CAMA 2020 covers these aspects, but I'm not so sure about that. So in conclusion, it's important for business owners, startups and SMEs to be properly sensitized on the potential value in their IP assets and the possibility of using it or utilizing it for financing options. And then consequently, financial institutions, lending institutions must also respond to this corporate innovation and then create favorable terms to encourage accessibility. So that'll be the end of my presentation. Thank you.
Thank you so much, Sewese. Over to Mr. Folari or Mr. Max to speak on it.
Max isn't available. I think that was a very, very excellent presentation. You know, I think it captures most of the live issues, you know, of the day when talking about using IP as bankable security. Interestingly, we actually just concluded a session on IP valuation recently. I think Juliana was at that session, and so it's quite interesting. In Nigeria, you know, I don't think there's generally I don't think there's difficulty in most parts of the world with valuing IP. You know, because if you look at some of the biggest portfolio purchases over maybe the past 10 years, IP portfolio purchases. I mean, if you look at the purchase of what's this company? Kodak. Kodak had gone broke, but they had a very huge portfolio. I think Kodak was ultimately acquired by Kodak's IP portfolio. The patent portfolio was acquired by Nokia. If you look at a company like BlackBerry, you know, if you look at, and even in the music industry, when Michael Jackson died, you know, there was a huge row over the ownership of the Beatles catalog, the famous Beatles catalog, because Michael Jackson had one of the largest and most valuable song catalog portfolios in the world. You know, if you look at, so over the past like decade or 2 decades, you'll see that it hasn't been too difficult to recognize IP, you know, valuable IP portfolios. And to that extent, I think we can easily say that in most parts of, in other parts of the world, IP valuation is not a problem. In Nigeria, however, you know, I think we do have some of the common challenges that, you know, you find in a developing country. So, but I think one of the reasons why we have that challenge is that it's centered around the fact that even we professionals, you know, we've not started to treat IP assets as, you know, valuable assets that can be used as security, you know, for a loan. I've seen, okay, good night. I've seen situations where, you know, I'm a lawyer, so let me speak as a lawyer. I've seen situations where, you know, a bank has collected somebody's call to bar certificate to use as collateral for a loan. I've even seen a situation where the police have asked for a call to bar certificate as what's it called? You know, as security for bail. You know, but a bank can take call to bar certificate as security for a loan, but will not take a trademark certificate or a patent certificate as you know, security. So IP valuation is a thing. I think it's at the root of IP management. It's really the foundation of IP management, because we're talking about value, and that you cannot work in the financial industry without, you know, having some kind of basic agreed framework for determining the value of the thing. So I think some of the challenges that we faced in the past will soon be over, you know, especially as more people become familiar with the valuation methodologies, you know, either using the pricing method or the market method, you know, any of the 3 methodologies that, you know, one is using. If you look at fintech, the fintech industry in globally and in Nigeria, the fintech industry is actually built on valuations of intellectual property, and the intellectual property is the code, you know, the source code. That's the code used to write the software, the processes, and essentially the intangible assets of the business. And just the other day, was it Flutterwave? Flutterwave there was a company invested about 200 million USD into Flutterwave. I have a client who recently, is this live? Okay, who recently raised, upwards of about 100 million naira, on a fintech company, essentially just a company with software, products and software services. So you find there's a huge, the valuations of fintech companies, which is largely based on the intangible assets of these companies, show that there's a lot of value, not to abuse the word, but there's a lot of value in IP. So I think, especially as far as the fintech industry goes, we're already using IP as a system of value. Either people are buying shares, taking equity, or giving facilities, getting funding and all that. So I think to a large extent, we will have some of these, we will start to see these things develop in Nigeria as a matter of reality. I think one last thing I would like to say just on this point, since we're talking about using IP as security or determining the value of IP, I think there's also a need for the judiciary to come on board, with regards to IP valuation. If you were to take a snapshot, an overview of cases, Nigerian cases, that where the courts have had to determine the value of either a song, a picture, or some form of IP, it would almost appear as if the courts apply some kind of voodoo magic, to determine the actual value or the rate of usage or whatever of this intellectual property. From the case law, valuation, determination of damages as nominal damages and the value of an IPR is actually a question of fact and not an issue of law. But sometimes our courts kind of miss the way when arriving at a figure. This Wema Bank case, the Anoliefo case, I think that's her name, the one of the model whose picture was used by Wema Bank on a motivational post. The Federal High Court awarded about 10 million naira in damages against Wema Bank. What was the basis for calculating that figure? And if you look at some COSON cases, I think over the past 5 years or 6 years, against some of these banks and multinationals, you hear hundreds of millions of naira. And what's the basis for calculating or arriving at these fees? So I think the costs actually need to be brought on board with regards to valuation. But very fantastic presentation, I must say. Some of those financial products, our markets don't have the complexity or the capacity to handle them, but well researched and well presented.
Thank you so much, sir.
You're welcome, Christina.
All right. So
I think Mark is good to go.
Okay, Mr. Max. Mr. Max, are you there? Seems is not around yet. So we just
maybe he's already trying to get into his plane, so maybe he's already boarding. So we can just end it here, I think, for today.
Thank you everyone for attending today's session. Okay. Thank you everyone for attending today's session. Thank you, Mr. Marks. Thank you, Mr. Folarin. Thank you to all of our mentees. The activity for next week will be passed across to us during the week. Do have a lovely weekend, everyone. Thank you so much. Good night.
Good night. Thank you, Christina. Thank you, everyone.
Thank you.
Have a